Welcome to Ask an Attorney, Florida Elder Law and Medicaid Planning.
Welcome back to Ask an Attorney, Florida Elder Law and Medicaid Planning with John Frazier of Pippin Law Group PLLC. John Frazier is a Florida Elder Law and Medicaid Planning attorney based in Largo. With advanced degrees in business and tax law and experience helping more than 3,500 families secure long-term care coverage, his practice focuses on almost exclusively on protecting assets and helping clients qualify for Medicaid benefits the right way. I'm Evan Mack, and today we're talking about the biggest Medicaid planning mistakes families make before seeking legal guidance. John, sir, welcome back.
Hi, Evan. Thank you for having me this morning.
Pleasure's all mine. John, when a family starts trying to handle, Medicaid planning on their own, what is the most common mistake you see in the state of Florida?
I think transfers to other family members are probably the biggest problem. I think people have heard that there's the $2,000 asset limit, so they think, well, we'll just give all the assets away and then apply for Medicaid. If it were that easy, there really would be no need for elder law attorneys, and everybody in the United States would be on Medicaid if they didn't have those look-back rules, and everybody would just give their assets away, and everybody be on Medicaid.
Yeah.
So that's probably the biggest issue.
Yeah. So why can giving assets away to children or relatives create serious problems under Florida's 5-year look-back rule?
The state of Florida has adopted a 5-year look-back as of many years ago. The Deficit Reduction Act of 2005, which went into effect in Florida in 2007, imposed that 5-year look-back. Prior to that, we had a 3-year look-back, but the state of Florida made it more difficult with the 5-year look-back. So the goal is to prevent people from easily getting Medicaid, and that's why they have the look back.
So, John, some families try to spend down assets quickly without guidance. What tends to go wrong when they start doing that?
I think some families do that. I really see more of an issue with trying to give the assets away. A lot of expenditures on the Medicaid applicant or spouse are actually permissible. So, for example, I had one client spend close to $100,000 on their homestead property. So they spent a bunch of money fixing up the house, new roof, landscaping, furniture, countertops. That's actually permissible because it's not giving the money away. So I think expenditures on things like that, which are considered permissible, are not a problem. So I think really the gifting issue is the biggest thing that comes up. People just trying to do the gifting because they hear about the $2,000 asset limit.
How do improper transfers or poorly structured financial moves affect the timing of Medicaid eligibility?
I think, if the family thinks, well, some families may think there's still a 3-year look back. So they may do a transfer and then wait 3 years and think that the person's ready to apply for Medicaid. Then they find out there's actually a 5-year look back. So I think that that's one of the things that could be problematic.
There are, non-attorney Medicaid planners and advisors in Florida as well. What risks should families understand before working with someone who is not a licensed elder law attorney?
I think there are many, many risks associated with that. Actually, it reached a point a number of years ago, and I'm actually the co-chair of the Unlicensed Practice of Law Committee for the Florida Bar Elder Law section. And I've been in that role for, I think, approaching 15 years now. Leonard Mondeshine has been the co-chair for a number of years also. Way back about 12 years ago or so, perhaps a little bit longer, I actually petitioned the Florida Bar to issue a Supreme Court, issue a draft advisory opinion to go up to the Florida Supreme Court, which would have to approve it, addressing the activities of non-attorney Medicaid planners. It took quite some time to do it, but the Florida Bar initially agreed to do that, went all the way up to the Florida Supreme Court, and it was approved by the Florida Supreme Court in 2015. So we've had additional rules regulating the non-attorney Medicaid planners since that time. And basically what it says is that the non-attorneys are allowed to file Medicaid applications. They can make copies, but they can't prepare any legal documents and they can't give legal advice. So, and that has been designed to prevent the non-attorneys from engaging in the unlicensed practice of law. Unfortunately, we still have a number of non-attorneys out there which are allegedly doing those sorts of things. but there's only so much that can be done. Ultimately, it's the Florida bar and the state prosecutors who are charged with enforcing UPL rules and UPL statutes. And I kind of get the impression that unless a person actually pretends to be a lawyer, so let's say you have a non-attorney puts up a fake diploma and falsely states that they're a member of the Florida bar. I think there's no doubt that the Florida bar and the state prosecutors would go after that person rather aggressively. But I think there's a number of, I've never heard of a non-attorney Medicaid planner doing something that egregious. So I think what we've seen is, allegations of giving legal advice and not being an attorney. And I think there's a couple issues which I think can prevent enforcement. One thing is the First Amendment. So we all have a First Amendment right to express our points of view. So when does it cross the line into UPL, or when is it permissible free speech? So I think we've got that issue. We've also got some antitrust considerations, I think, potentially, because I think really any professional license is a state-issued monopoly to a certain degree. So federal courts can get involved if any of the licensing agencies overstep their boundaries and prevent non-attorneys or other unlicensed individuals from doing things which they might be allowed to do. And then those state licensing associations can actually be brought into federal court and sued under the antitrust statutes. And so that would be a very, very bad thing for a bar association. Or there was a case involving dental assistants in another state. It was like a very large lawsuit. There was another case involving LegalZoom, a non-attorney group. A multi-million-dollar lawsuit was brought against a state bar association. So we've got, some things which have to be considered: the First Amendment and antitrust rules with respect to regulating the unlicensed practice of law.
Ooh. So you kind of mentioned LegalZoom, but how does that do-it-yourself estate planning documents sometimes fall into long-term care situations?
Well, sometimes it can be okay. The biggest problem that I see are powers of attorney lacking all the Medicaid planning authorities. That's one of the biggest limitations. About 25% of my clients need something called a qualified income trust. The state of Florida has an income cap. This year it's $2,982 a month. So let's say that you've got an unmarried Medicaid applicant with $3,000 a month in income. They need something called a qualified income trust. And the Florida Department of Children and Families Legal Office has taken the position that the Medicaid applicant cannot be the trustee on those trusts because they believe that the Medicaid applicant has unfettered access to those funds, therefore putting the person over $2,000. I think, there's an argument that that may not be correct. But the bottom line is the DCF legal office says that the Medicaid applicant can't be the trustee. So for an unmarried person, we typically need to have a properly drafted power of attorney where another person can be the trustee. We see lots. I've probably seen thousands of powers of attorney in the past 25 years that are lacking trust creation authority. And we are regularly redoing powers of attorney that were done by non-attorneys. And LegalZoom is an example of that. Their power of attorney actually does not have trust creation authority as of at least 10 years now. So when we see a LegalZoom power of attorney and we need an income trust, we have to do a new power of attorney.
So what happens when families wait too long to explore planning options and, a nursing home replacement becomes urgent?
Well, one of the biggest problems is my typical client is 65 or older. Unfortunately, many of them have dementia and Alzheimer's, and we all know that that is not curable. They're progressive disorders. So if you've got an individual who's developing some dementia and they don't have a power of attorney, at some point, they're probably going to lose their ability to understand what a power of attorney is and therefore cannot do a power of attorney. So if you've got an unmarried Medicaid applicant with no power of attorney, really the only option is guardianship. And that's an expensive court-ordered process where the court tells the family what needs to happen with the assets, and you have to get court permission to do everything for the Medicaid planning. So that's one of the biggest problems of waiving and not addressing these things early. Everyone should have a properly drafted power of attorney with a person, naming a person who they trust. Because when you grant the authority, that's like having the keys to the bank. So you need to make sure that whoever you give that power of attorney to does not have a gambling problem, a substance abuse problem, things like that, because that could create a risk that the attorney, in fact, may try to take the assets from the Medicaid applicant. It theoretically could happen. And you do hear in the news here in Florida, every month, there's a new story about a power of attorney taking the funds of an elderly person.
So, John, can you share an example of a situation where a small early mistake ended up costing a family a significant money, time down the line?
That's a classic example, the power of attorney issue. So let's say we've got a power of attorney that looks pretty good, but no trust creation authority. If that Medicaid applicant has reached the point where they can no longer sign a power of attorney, we cannot do a qualified income trust with that power of attorney. Now, there has been a way around that in some cases. There have been 2 appeals with the Florida Department of Children and Families regarding this issue of trust creation. And so there's another type of trust that can be used, which is similar but different to the qualified income trust. It's called a special needs pool trust, authorized under the same federal statute. The authority needed in a power of attorney to join a special needs pool trust is less than the creation of a qualified income trust. So luckily, in a number of cases where we don't have trust creation authority in the power of attorney, we've been able to use the special needs pool trust instead with these powers of attorney, which have more limitations, and get those cases approved by DCF legal counsel.
So, John, for families who want to avoid these pitfalls, what should they have in place before a health crisis occurs?
In my opinion, for my practice area, a properly drafted power of attorney is the number one most important thing. There are other important documents. Living will generally is very important. That doesn't impact Medicaid planning. Basic estate planning documents are also very important. A will or a living trust. But again, those documents do not impact Medicaid planning. They won't. The lack of those documents won't prevent someone from getting Medicaid, but the lack of a properly drafted power of attorney or not having a power of attorney at all will prevent an unmarried person from getting Medicaid, and sometimes a married Medicaid applicant too. There are circumstances when the person's married where the spouse can do certain things and perhaps sign certain things for the Medicaid applicant. But I would say that everyone should have a properly drafted power of attorney, no matter what.
John, thank you so much for your time, sir.
All right. Thank you very much.
Right. That's it for today's episode of Ask an Attorney, Florida Elder Law and Medicaid Planning. If you'd like guidance on Medicaid planning in Florida or want to avoid costly mistakes before long-term care becomes urgent, you can visit estatelegalplanning.com to access free resources and schedule a consultation with John. Thanks for listening, and don't forget to subscribe, share, and leave a review if you found this episode helpful as well. Thank you so much, and we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.